My name is Denis Nyombi. I am a legal and political analyst. I look at various issues within Uganda, within the region, and outside Uganda, in a legal and political angle.
You're welcome, Counsel. We are to discuss a number of issues today. First of all, the massacre court committed Allan, Ssewanyana and Ssegirinya to High Court. Should we expect to see the suspects now taken to High Court and start the due course of the law?
Right. Okay. First, when you say court committed, we must understand which court and what took place. It is the magistrate's court, the chief magistrate to be specific, who commits the accused in capital offences to the High Court. So yesterday the chief magistrate's court of Masaka committed the two accused persons to the trial before the High Court, which means that their case is now due to be heard by the High Court in Masaka. However, to be specific on the question, it's not that now that the court committed them, their trial is going to start tomorrow or Monday, Tuesday or Wednesday. When you are committed, your case awaits the next nearest session.
Right.
So we are not certain when will the High Court have the next criminal session fixed in order for this person's case to be heard. That's another challenge, because when an accused person is committed for trial in capital offense, the session may take long, may even take 6 months, or the next session may be full and the person is fixed yet on another session, which you may say a second session. There are a few exceptional circumstances where a person may be fixed on the next nearest session. If they have health ailments, if they are persons of a relatively older age, those are some of the few instances we can look at. So we really call upon the Judiciary to give these two persons a quick observation that their case is fixed on the next session. Why? There is something exceptional with the two accused persons. These are members of parliament. Each one has a constituency that they represent. Now, the people in their constituencies, Machingi and Kyaggwe, expect their constituencies to have representatives in parliament. Now, if there is a delay in their case being heard or a delay in their case being put to the session, it doesn't affect them, the accused persons per se, but it also affects the electorate. Because apparently, is it Machingi East that Honorable Allan represents, and Kyaggwe is the South that Honorable Ssewanyana represents. So the constituencies have no representation before Parliament. But above all, it's not only Allan Ssewanyana, not only to Ssegirinya. All accused persons must have expeditious hearing of their cases. No, not only the two because they are MPs, no, but all accused persons have a right that their cases be heard expeditiously. When a matter is delayed, then it transforms into an injustice. That's why we say that justice delayed is justice denied.
Yes. Still on that issue, for how long does it affect their representation in Parliament?
By the way, that's a very good area. Do you know, if you don't attend Parliament, is it? I'm forgetting the number of seats. You are deemed not to be an MP. That can lead to your censure from the House.
Yes.
You cease to be an MP.
So, being
now,
the opposition MPs, can't the government play that hide and seek? to affect their representation.
Your question already has an opinion. The same being opposition.
Yes, MPs.
If I were asked to answer the question in a lay
man's language,
not layman's language, but in a lay or a pedestrian lineage, I would say it's possible. But now where I am, you may ask me, how do you prove that? But you know, this is a game of politics and the law. There are consequences that may arise from this act. Some of the consequences are the absentia of these two persons on the floor of parliament can result into their losing the seats. Now, there is a trial going on. The question we need to ask ourselves is whether the trial is a reason enough to enable them, even amidst their absentia in the House, continue their seats, such that the other requirement, the other position of the law, that if someone misses attending to parliament for a number of days, they can lose their seat. So, whether the subsistence of a trial against them can account as a reason to exonerate them from being victims to fall the exit from parliament pursuant to that law. That's what we need to look at. But where politics and the law interface, come hand in hand in a play, anything can happen. Let me give you an example. In South Africa during the era of apartheid, most of the things that the government that was occasioning apartheid did were backed by the law. So they would report that they say, yes, what we have done it under the law. Generally everything was legit, but in reality it was inhuman, it was unfair, it was segregation. So wherever there is a clash of politics and the law, anything can happen. That's what I can say.
Yes. So when we go back to the delayed justice, we can go a bit into the case of Mirembe and Kirabo, that is in Mukono High Court. We've seen the offense was committed some time back in 2015. Right. It has taken over 6 years when the suspect was given court bail. So right now, what is the status? And of recent, we had a court asking the sureties to pay a certain amount of money, that is bail terms, for failure to produce the suspect. So what does this mean, and what is your opinion as far as this case is concerned?
My opinion as far as the case is concerned is that the case puts an illustrate of some of the occurrences that can arise if hearing a case takes long. This is what is meant by justice delayed is justice denied. Now, for over 6 years, the matter has never been heard. The time it's been started to be heard, a few witnesses presented to court. Then as the prosecution was about to close its case, the accused disappears. Of course, at that juncture, the sureties had to fulfill their bond. When someone stands a surety in court, they make a promise, a confirmation that we are obliged to present this person before court as and when they are called upon. And when they fail, it's incumbent upon court to summon them to effect their obligation. If they fail, the obligation that is to present the accused person before court at the trial. Now if they fail, then they have to pay the amount of money that was due. Now in this case, the sureties were bonded on 50 million shillings each. So they had to pay the 50 million shillings each, which amounted to 150 million shillings. But the question is, even if that money was paid, is there justice at the surface? No. So, if a trial takes long, these are some of the challenges, these are some of the problems that culminate. Even, let's go away from the case of Desire. There are so many people in different prisons So many people. Their trials have never picked off. You understand? And there are so many relatives and friends that are yearning for justice. So many. I want to believe, even up to now, in the just concluded elections, January 14th, in the subsequent, before the voting day and even after, there are so many people that were arrested for different reasons and for different cases in different parts of the country. We are a country of about 146 districts, a country of 70 villages. Different people were picked from different places. Many of them, until now, have never faced trial. You do recall the different statements in terms of the numbers of people that were in the hands of the security forces, in the hands of the prison, that were brought on the floor of parliament. Different ministers had different numbers. So until now, I am personally still convinced and satisfied that so many people have never met a courtroom for a decent, fair hearing in their cases. So among the challenges that come with that is sometimes the witnesses disappear, others die, exhibits disappear, exhibits get destroyed. At the end of the day, there's no justice. It's an area that's going to be really worked upon by all stakeholders, the government, the judiciary, the police. They all have a role to play in this. Let me give you an example. Just of recent, and actually today, new magistrates have been deployed or assigned stations. But the country still has a problem of the number of magistrates. Different areas do not have magistrates in magisterial areas. People still move long distances to meet and seek justice. In the High Court, where most of these capital offences are tried, the little number of judges is wanting. You understand? Now, these are the areas that need to be worked upon to see a roadmap to justice being built. But so long as the situation remains as is, these and more are going to be seen, which at the end of the day does not grow our jurisprudence, judicial system, the criminal justice system at large.
Yes. If we go away a bit from that, going back to the case of Ssegirinya and Allan Ssewanyana, do we have some political cases? I can give you an example, the case of Honorable Nyombi, HT Charles Peter Maiga, Honorable Segona. When they were arrested, those days we were saying kidnapped and taken to very far places. They were made to tour the country, but in an unfortunate manner. Right now they are on bail, court bail, but years have gone, and they don't know whether the cases were cancelled, whether the state lost interest in the cases. So we have a number of cases that are into that.
We call it non-starter.
All right.
Actually, let me give you this for the record. In the just concluded presidential elections, Janot Mukonde stood as a candidate. He was on bail. Robert Kyaggwe stood as a candidate. He was on bail. And I think it was Kyaggwe was prison. He had a case in Arua, I remember, it was prison. Janot Mukonde had a case before court-martial prison. Betty Nyombi, not stand for presidential office per se, was a member of parliament, municipality. But remember, she's on bail on a case of the killing of Ability. Right? Then Kizza Besigye, until of recent, he's been on bail. So most of the leading politicians are moving on bail papers. Now, the reality is this: there's a very big fusion between the law and politics. Our political system has been built to create a situation that if you stand out politically to critique the regime, you are susceptible having a very big charge against you. Actually, I remember during that time there was an article in one of the leading dailies that a charge of treason in Uganda is a rubber stamp to confirm that you are now an ideal politician in Uganda. If you've not yet been charged with treason, then you're still wanting. Your political ranking is still wanting. So, it's true. There are many instances where we have seen cases being tried, charges being brought against politicians for political purposes or for political motives, politically driven. Not only in Uganda, but even in many countries in Africa, this still takes place, and these matters still happen. The only challenge we have is this is not something that's about to end today. We are even going to see it, even when you come to 2026 elections. Some script, that's what you're going to see. Cases are going to come on board. Now this is where we, the critics of the argument, that in certain cases, like capital offenses, the right to apply for bail should be toned down. We do not trust the system that when it comes with proposals of this nature, it's coming with a bona fide hand, an innocent hand. We are highly suspicious that to tamper with the right to apply for bail at this juncture is to create room to deflate those willing to stand or to run against the status quo, and they will be subjected to trials, but without having a chance of attending these trials while coming from out. Like you saw in the previous local elections, General Tumukunde was on bail, but was a presidential candidate. Robert Kyaggwe was on bail, but was a presidential candidate. Now, if we go by this, the amendments that the amendment being proposed, don't expect to see that in 2026. And even on the parliamentary level, because you will not be able to stand. They will not bring an effigy like it was done in the past for Kyaggwe. They brought an effigy for nomination. So these are some of the challenges that we're having. Let me also point this out. How do people look at the regime when it makes certain proposals like this? I want to give you an example. It's true, and I'm going to give 2 examples. We do have challenges in the land law, in the land system in our country. But have you taken observation that wherever the government comes up to make a proposition of amending the land laws, there is a mistrust coming from the people. People don't trust the regime when it comes to making proposals on aligning land matters. There's that mistrust. I don't know whether you've observed it. Let me also give you an example. I don't want to seem to be speaking into the depth of the case in Masaka. But whereas it's so saddening and hurting that innocent lives passed on in Masaka, but there's a general mistrust as to whether the 2 accused persons and others, but the 2 accused persons, actually it was an astonishment upon the news coming out that the suspects in the massacre killings are these 2 persons. It didn't go, the news didn't commensurate with the anger, with the shock that rovered around massacre. I don't know whether you pay attention to that. So there's a mistrust from the people towards certain government propositions, policies, and acts that are seemingly coming out, maybe to put up something right. That mistrust is what that's summoning the government to pay attention to itself. But of course, it's not something that's going to change today, that's going to change tomorrow. No. The DNA of the system is clear cut.
Yes. So, when we are into that kind of scenario, Where is the justice system? Where is the judiciary?
It's in a sorry state. The judiciary is in a sorry state. Why? First of all, a case to appear in court, let's look at a criminal case. It involves so many stakeholders. We have the police, which does the investigation. We have the office of the DPP, which does the prosecution. How are all these other offices working in order to see the judiciary do its work? How, I told you in one of the interviews before, how are these cases investigated? In one of the cases, that was the trial of Kyaggwe, the first case. During cross-examination, one of the investigating officers was asked whether they reached that particular place where the head that young boy's head, that was Ssegirinya, whether the police reached that particular spot where that head was. And the IO said no. The question was why, and said there were bees. We were scared that the bees were going to sting us. Are you getting the point?
Right.
Now, I want you to look at, of recent, we have had a very worrying state of the Muslim clerics that were murdered. You've already seen the police come to the crime scene and carry out its investigations. But these investigations have never brought results on the table. What do I mean? No judgment has been presented. Even some of them, the trials are not yet in high gear. How are cases investigated in this country? Who investigates these cases? How equipped, knowledgeable, prepared, skilled are the investigators? These are some of the areas that we need to first look at. The people who do the investigation, they present the reports, they present the exhibits to the office of the DPP to prosecute. Do they do their work? Now, if improperly prepared work is brought on the table, what do you expect court to do? Yes, court also has its challenges. Like I said, sorry state. There is a number of judges, a number of magistrates. Accessibility to courts in different places. Okay? You have a magistrate in, for instance, Lugazi. That's a very magistrate who will go and attend to court in the islands. On the day that magistrate will go to Ruvuma, the cases at Lugazi will not kick off. The best they can be given is an adjournment. You have a magistrate sitting in Mukono. At the same time, that magistrate must sit in Kayumba. On other days, must be in Mukono. So the day that magistrate is in Mukono, the cases in Kayumba will not kick off. The best they can get is an adjournment. So, all stakeholders in the arm that builds justice have a role to play. There is so much that needs to be done. How are documents, records kept in courts? You have heard of stories that documents are pulled out of files, exhibits get lost. Now all these are areas that different stakeholders who have an arm in these corners must improve in order for us to have an improved better justice system.
Yes. The country like Uganda is supposed to be governed on the executive, legislature, and judiciary. Those are the three arms of government. So, do we still have these three arms of government in Uganda? According to what you've just given us.
You know, we have a challenge. In Uganda, for instance, the legislature and the executive, you fail to understand who is in charge of the other. I want to give you a few instances. The legislature, a few days ago, in the course of MPs doing their work, they raised the question towards the Minister of Science, Honorable Ssegirinya. And the head of state said, no, this is a decorated science. You don't need to question her. I also want to take you back. During the COVID time, I think that was really the first wave, there was an issue to do with money that the parliamentary commission passed, that the money was supposed to be given to MPs. Mr. Museveni, the head of the executive, raised concern over that. There was a debate whether, in regard to money spent by the parliamentary commission, the executive has a role in questioning the expenditure of that money. And so many other instances. So, outrightly, if I may give you the mother of all instances, I want you to go back on 27th September 2017, during that time when there was a move to amend the constitution to lift the age limit. You remember what happened? In Parliament, and up to today, several MPs still move with windings. It was a clear illustrate that there's a disrespect of one of the entities, because there are three arms: the judiciary, the executive, and the legislature. But the acts of the state then were an insult to the legislature. Now, and so many other things are taking place, which leave a very big question mark whether in an ideal situation we have the independence of the judiciary, the legislature, and the executive. At one time, there was a time Parliament was following the matter, and the judiciary issued an order to restrain Parliament from discussing that matter. That order was issued by Justice Kafumazdi was. And you remember how the Speaker of Parliament then, Honorable Rebecca Kadag, labeled the same as a rubbish order, something like that. So we've seen this. I'm not saying there's a perfect situation where these three arms of government don't clash. Even in the UK, where we adopted this system, these things happen. There's that clashing. But the clashing is not to be taken in a bad faith. Sometimes this is how democracy grows. The purpose of the debate is to have different views. The different views, the different opinions, and the different arguments help a nation to grow. That's why it's sometimes worrying if, when the members of Parliament of the opposition side restrain themselves from sitting, it becomes hard for business to flow whilst it's only the members of the ruling party in the House. Because there is a need to have debate. Debate is healthy for growth of our democracy and the country at large. So, in summary, what we have in Uganda is a one-man show. I want to be explicitly clear. Mr. Museveni said that in Uganda, he does not chair cabinet, save when there is a very sensitive matter. But he's the chief security officer, the chief economist, and the chief political commissar. During the 2 lockdowns, this was manifestly clear. In the previous address, Mr. Museveni gave to the nation, he made a very clear statement. He said that he monitors these security operations and he reads security reports, which is true. He also said that the people who were killed, the ones that were shot dead, to be specific, Sheikh children, these were suspected. I don't know that you're getting what I'm saying. We are certain that if we have a system where we have 3 arms of the government, each one has to do its work, you do not kill a suspected person where you have a judiciary. That's not legal. That's not legit. That doesn't sound a due process of the law. You have a suspect. You have courts of law. You have the Directorate of Prosecution, etc. But you opt to shoot a suspect and kill that suspect. That answers your question, whether the 3 arms of the government are indeed existing and functioning as ought to be.
So you were following Kyaggwe TV. We are having Counsel Denis Nyombi giving us the lawyer's perspective on a number of issues. We're going to have a break, and as we come back, we shall also get another topics to discuss.